Hello, everyone. Again, I apologize for the delay in getting started today. My name is Lisa Nelson, and I'm the Leavitt Group Vice President of Compliance and Regulatory Affairs, as well as the Corporate HIPAA Privacy Officer. It is my job to help support you, the self-funded health plans, and our other clients understand and comply with HIPAA, and we have a full suite of resources to do that. This training here is a little bit at the 10,000 foot level. We can go much deeper. Believe me, I have, and I will talk all day about HIPAA if you give me the chance. I consider myself a little bit of a HIPAA nerd. So we have more in-depth training as well. If you happen to be someone at your organization who requires more in-depth training, so thinking anybody who's more intimately involved with sort of the day-to-day HIPAA requirements, such as your benefits team, sometimes HR folks, depending on how your organization is formed and the structure is. So just know we have more. Today, the focus of our presentation will be self-funded plans and level-funded plans, and we'll go over what that actually means in a little bit. I will, for easier consumption, oversimplify where common practice will allow. So I might breeze through some of these slides. The slides are available to you after our presentation today as well. So don't feel like you have to write down everything that I'm saying. If you at all try to. Feel free to reach out if you have any questions about anything we go over or any other compliance related matters. I am here to support you and our team at Great West as well. So some things happen, right? And so what do you call an urgent HIPAA issue? Well, here we call it hypocritical. Let's not be hypocritical. We really want to pay attention to what we must pay attention to. And for purposes of our conversation today, I'm going to go high level and focus on 5 main areas that you would have to be concerned with as a self-funded plan. And we're going to really focus on the top 3. I kind of go backwards a little bit in the interest of time, and hopefully you won't have the end of the day tired, and that sets in usually this time of day as well. So we'll cover the top 3 right off the bat. The key takeaway for today is training. So congratulations, you've made it through your first HIPAA requirement, and that is completing HIPAA training. So it is the main requirement of HIPAA. So I always like to say hip, hip, HIPAA, hooray, but usually on the Zoom, it doesn't go over quite as fun as it does in a room. So I'm gonna assume all you guys out there in the black boxes that I'm looking at are doing the hip, hip, HIPAA, hooray with me. So training is flexible. So something that some people might not know about HIPAA is that the rules are slightly flexible depending on how involved an entity is with sensitive information, specifically protected health information. So training is one of those areas that will be slightly flexible as well. So it's typical to see an annual or biannual training. That's most common, but it's important to just determine what is most suitable. So if your self-funded plan happens to do a lot of review of your plan utilization, maybe doing some wellness outreach, and you're getting involved a little bit more in your benefits than, let's say, a San Francisco or a plan who, sorry, my phone rang and then I got distracted. I lost my train of thought when the phone rang. Sorry about that. It's most common to do biannual, annual, but you want to determine based on how involved with that sensitive information you are. So if you are quite involved, I would do annual. If you're less involved, then every couple of years. Who you train is also slightly flexible. I'm going to assume if you're on this webinar today, then you might be somebody who needs to be trained. And you might also have an idea after this presentation today, who else might need to be trained. Typically, we train anybody who's coming into contact with sensitive information, HR, benefits. We even do light training typically for IT folks, somebody we might not think of, and that's because IT people can see everything, right? They can see every email you have. Typically, we could do a handout training. You don't even have to do a training like we're doing today. Training can also be slightly different depending on the audience that we're talking about. So in IT, I would typically give them a handout, maybe a handout of these slides, and just say, review it, sign this acknowledgement that you've read it and understand it, and call that training for them. Versus HR, who's doing this day-to-day benefits. Maybe the employees are reaching out and asking questions or asking claims assistance help. Then those people you might want to make sure that they're doing this more robust training. Even the more robust than this that we're doing today training may be warranted for some of them. We also recommend, if you're doing an annual, and then especially if you're doing a biannual training, that you also consider additional ways to supplement or remind your employees that come in contact with sensitive information about the HIPAA rules. So we do a quarterly engagement, and this can be an email or a game or a meme. It doesn't really matter so long as you're getting that touch point. You could do it at a sales meeting, you could do it at your HR meeting. It doesn't really matter so long as you're having some other reach out or a touch point with them throughout the year instead of that once a year training. So you might do things, just a reminder, make sure you're checking your recipients when you send emails, something like that. Just one part of the rule, just a little reminder on. So that's highly recommended as well. So we talked about training. The other number 2 most important requirement under HIPAA is to have your appropriate contracts in place. So before you share any protected health information, you should have a contract in place with the other entity before you share it. Now, the exception here would be for fully insured plans with the carrier. That contract essentially isn't a true contract. It's a certification that's in the plan document that just says the plan complies with HIPAA, and then the carrier says, okay, good. And then they send you the information. But with self-funded plans, you need a business associate agreement signed with your TPA, your broker, literally every service provider that you have, you'll probably need a business associate agreement with if you are providing them any protected health information to help administer your plan or help with some portion of your plan. So it's always recommended you use your own template if you can. If you have your own legal counsel, or you have a HIPAA privacy officer who has their own version, you can use your own. You don't have to use your service provider's version. Always pay attention to time frames in those contracts as well. You want to know if something occurred within a reasonable time frame. And the contracts will go into more detail if you're one of those individuals who need those deep details, that deep dive, and in another presentation. But there are timeframes that are important in the business associate agreement to be mindful of. We also have versions of the business associate agreements. We have templates we can provide you as well if you don't have one. So business associates are those companies or entities or individuals who are helping the health plan with some function of administering the health plan. So it could be your TPA, your broker, sometimes COBRA vendors. You have wellness coordinators, data warehouses. It could be multiples. You could also have a business associate that you have entered into a business associate agreement contract with, who then also hires another entity to help them fulfill their agreement with you. And those are called subcontractors, and they as well need to have a contract. So I like to think of it as a circle. Everyone who is sharing information within this circle needs to have a contract or be directly subject to HIPAA like an insurance carrier is, and therefore already complying. So the takeaway here is to remember your contracts before you're sharing any protected health information. And whenever you're doing contracts, keep in mind too that there are also state privacy laws that might need to be considered in those contracts as well. And we'll talk about more of that in a minute. And then our final and most important of the top 3 items is probably what I call the most annoying of them, and that is potential breach or security incident reporting. So something happened if you sent the email to the wrong recipient, you mailed protected health information to the wrong recipient, you in some way had protected health information inappropriately accessed or sent to the wrong party, that could be a security incident. And we always call it potential security incident rather than breach wherever possible, just because one assumes a higher level of obligation than the other. So just keep in mind, there is a process. If there is something that happens, there is a process that must be done. So there's an investigation, there needs to be records of that investigation, and we at Leavitt Group have sample templates that we can provide you for that. You need to provide notice to the individuals that were impacted. We have templates for notice letters as well. And then if it's a large breach or potential incident impacting 500 or more individuals, not only is just the individual notified, but the Department of Health and Human Services, as well as the local media. So we don't want that one to happen, of course. But if you have anything that happens, we're here to help you, support you through all of that and figuring that out as well. So don't feel like you have to figure that out on your own. Following any incidents, there's usually something has to happen to make sure it doesn't happen again. It could be retraining, it could be a change in a policy or change in an agreement, but something must follow. If you were audited by the Department of Health and Human Services, it's part of them being satisfied with how you handled the incident, having conducted each phase of the investigation and the notice. So now that we covered the top three, let's do a little bit of the basics. So HIPAA and the health plan. So HIPAA, what is it? HIPAA is the Health Insurance Portability and Accountability Act, and I emphasize on those two for an important reason. So we may be familiar, those of you that are on the line, about you being able to take your health insurance with you when you leave the employer. That's COBRA, right? So that's the portability provision that actually originated in the HIPAA rules. And accountability, that's what the rest of us are really worried about. We're accountable to protect the sensitive information that we're interacting with, and HIPAA gives us several rules to do so. HIPAA does not apply fully to some plans. Disability, workers' comp, and life insurance plans happen to be areas where there's a lot of sharing of very similar sensitive information that would also exist on the health plan side, but you wouldn't need an authorization to interact with a third party in order to get those workers' comp or life or disability plans administered. And that's just because by way of the law, it's sort of a necessary thing to have a freer sharing of that information. Something that I just want to remind you of, make sure you only use one P, not two Ps like a hippo, but one P like HIPAA when you're spelling HIPAA. Sort of one of those things that grinds my eye when I see it. And it's sort of the first step if you're the HIPAA privacy person at your entity that you know to only use the one P. So HIPAA privacy and security are two different. HIPAA privacy came first, and then security really involves the electronic versions of sensitive information, so anything on your computer. But privacy really includes all of security as well. But privacy, we're really talking about your policies, procedures, training, how your office is set up, all of the having the computer screen facing away from the public walkway, sort of a requirement in HIPAA to have your setup in that way. Also the rights of the individual, which we'll talk about in a second. Now, we talked about what is HIPAA, right? Now, what is PHI? Because it's important to know that HIPAA does not apply to all health information, and that's a common thing that people can tend to think that could help save some of the work for you if you understand the difference. So you really need three components for it to be PHI and therefore HIPAA to kick in, and you have to worry about all these rules. It must be created or received by the covered entity. That's your self-funded health plans. It can include also the fully insured carriers, but that's not of your concern here. But all of your self-funded plans include flexible spending accounts and EAPs as well. and it must relate to the plan participants' past, present, or future medical condition, treatment, or payment for that. And it has to be identifiable. If you remove the identifier, then it is de-identified and it is not PHI. If you remove the medical condition or payment or treatment, then it is really more of a PII, identifiable information, but not relating to health condition. Then HIPAA wouldn't apply, but potentially some state privacy laws might comply. I always think it's a good rule of thumb just to apply HIPAA to all sensitive information. That is the higher standard of care. But where you're looking for some wiggle room, just be mindful. Some of the information that you're working with, some of that sensitive information may be state privacy, not HIPAA, and therefore a looser rule about how to comply. I'll say, you know, protect confidentiality, but won't give you all of these how you must go about doing it. So the health plan is obligated under the law. Business associates are obligated under mostly contracts that we have with the health plans, which is why it's important for you to have that with your business associates. And keep in mind, as the employer, you're also coming across sensitive information in your employer function. So think about which hat you have on when you're coming across that health information. Do you have your employer hat on? Sick notes, FMLA, workers' comp even, or do you have your plan sponsor hat on? So you're helping with benefits and claims and utilization. So think about which one. If you have your employer hat on, HIPAA won't likely apply, and you have a little bit of wiggle room there. What HIPAA is really worried about is how we're protecting the information. How are we talking about it? How much of it are we using? Where are we storing it? Who are we sharing it with? And then what happens if? So that's the gist of it, right? So it really applies to self-funded plans for purposes of this call. But we've also seen it ourselves, probably in our own personal lives, and doctor's office and other settings as well that I'll mention in a minute. And if you were an insured plan, let's say you're a self-funded plan, maybe you're considered going to an insured plan, or maybe you're coming from an insured plan to a self-funded or level funded plan. Remember I had mentioned to you earlier that there's some flexibility in application of the rules. So if you were an insured plan, that means the carrier has all the sensitive information and you technically shouldn't even have access to it. Therefore, HIPAA wouldn't really be a concern. So you're insured, you're hands-off only. That means you're not helping with claims issues. You're letting the carrier handle all of the business. Then as a plan, as an employer plan sponsor, you're really doing some basic training, and it would be something like this. Reconsider it every so often. If you get more involved with protected health information, you'll need to reassess your HIPAA compliance obligations. But if you add even one self-funded component, let's say you're all insured and you have an EAP or flexible spending account, those are considered self-funded because it's not an insured product. And therefore you would have to technically be HIPAA compliant. And I emphasize technically because in those situations, almost always the employer doesn't have really any involvement with protected health information. So it's almost a technicality that they have to comply because of the FSA and EIP standing and then self-funded definition. So we can provide you, templates that you can put on the shelf and know that you'll probably won't use a lot of them, but you'll have them if you're ever audited. But if you're a self-funded plan, you can access more information as a plan. And because of that, even if you don't, because of that, because you can, you have to comply with HIPAA more. So self-funded, even if you're hands-off, you still have to comply. You just have less to worry about, and your policies would reflect that. Your training would be less training. The individuals you would require to train would be less. If you were in fully insured plan and maybe a level funded, level funded, you're still in self-funded world. But if you're in an insured plan, you could still do a few things like enrollments, you know, referring to the carrier for claims issues, and still not be considered hands-on in the fully insured world. But as self-funded plans, you're already in the HIPAA world, as I like to say. I want to mention a couple of other rules that overlap with HIPAA so much that I find it worth mentioning. One is wellness. So there are HIPAA wellness rules as well. So we have HIPAA as it relates to how we're using, sharing, disclosing sensitive health information. And then we have wellness, which is incentivizing participation in the wellness program. Those of you on the phone or on the webinar today might be familiar with, you know, you could get a 30% discount off your premium if you participate in the wellness program, that kind of thing. So there are two sets of wellness rules there. So just know when you hear HIPAA, it might be this one and not the other one. Both of them you have to comply with. HIPAA for wellness. Just know that if you have a wellness team and they're doing any of the HIPAA stuff, you want to be thinking about HIPAA too. Even if it's your own in-house wellness team, we want to be thinking about HIPAA too. So reach out to your Leavitt group representative and make sure that you guys have talked about it. I'm sure they have talked about it with you already, but make sure you've mentioned to them if you have a wellness team that you're working with. And also the American with Disabilities Act, very common. This is on your employment side of the house. So as an employer, the employer hat, you're going to come across ADA requirements for leave, workers' comp. You need reasonable accommodations for any wellness program. All of that falls under the ADA. It doesn't require the higher level of standard that HIPAA does. So you would file it a little bit differently. So I like to say when you're storing HIPAA information, so HIPAA is that protected health information that we're talking about concerns your health plan, claims issues, census data, utilization review. Any of that would be the HIPAA folders. If you're helping with claims issues and you're doing authorization forms, you put them in your HIPAA folder and you have your HIPAA folder. You also are going to have an employer folder, and that's your employment law folder for ADA, your sick notes, because the HIPAA folder should only be accessed if you're really trying to access the most super secret information. That's your super secret folder. So you're going to have multiple access folders. You're going to have an employment folder, you're going to have, which is a confidential folder. Within it, you're going to have a medical folder, and within it, you're going to have a HIPAA folder. Always consider the state that you're in. Montana recently had a state law pass that will become effective in 2024 for state privacy, not as strict as HIPAA, but important to note. So take a look at that article that we wrote, linked on the slide there, to know what you must do next year for compliance. Most of the time, you really just have to make it part of your consideration and process if anything did happen with sensitive information on any of the employees or locations you have in that state. In Montana, Tennessee is another one. We have Florida just passed one, so we expect it to just spread across. I'm in California, and California has the CCPA, which happens to be the strictest one. In Montana, the privacy law excludes employment records. So if there is an incident involving a breach of employment records, you wouldn't necessarily be subject to the Montana law because they exclude the employment records, unlike California, where employment records are included, and therefore it's a bigger task for employers in California. So the HIPAA privacy rules, I like to break into the top 5 areas. And we already talked about training, and we already talked about business associate agreements. I'm going to mention individual rights in passing on this slide. So part of HIPAA is also the individual's right to a breach notification, right to amend, right to an accounting of how you're using the records. But I'm going to pin that because a lot of those have caveats. So it'll say, yes, you have that right, but there's also a requirement to use an authorization form. And there's a requirement to restrict the amount of protected health information you're using when you're trying to achieve a particular task. So we call this the minimum necessary standard, and that is to use the minimum amount of information needed in order to perform that task. So for example, if you had John Smith who had an amputation and the bill wasn't paid, you don't have to necessarily call the carrier and say John Smith had the amputation and his $5,000 bill for that wasn't paid. You might be able to say John Smith has a bill that wasn't paid, or I have a bill on an employee that wasn't paid. Think about where you could maybe remove some of the information in order to achieve the minimum necessary standard. Authorization forms are technically required if you're going to help any of your employees with claims issues. The HIPAA rules do not consider helping with claims issues to be part of administering the plan, because they believe that the employee, the plan participant, should go directly to the plan to get that issue resolved, not going through the employer as the middle person. So if you are going to help an employee with a claim and you have to share their protected health information in order to achieve whatever you're trying to achieve, then you get an authorization form. It's one page. It says you authorize providing this. There are certain marks that must be made for sharing of particularly sensitive information like substance use or psych records. So all of that has to be provided. We have templates that we can provide to you for that as well. If you need it, just reach out to your Leavitt Group representative. Now you can get around the authorization, just what I mentioned earlier, removing an identifier or removing the medical information from the conversation. You could get around that authorization, because remember, you need the three things in order for it to be PHI, in order to then HIPAA be concerned with. You need to have it come for the covered entity. That means from the plan or the carrier. It needs to be identifiable, and it needs to be about past, present, and future medical condition, treatment, or payment form. So if you remove one of those, then you don't need the authorization form. The individual rights. So I mentioned this earlier, there's a lot of caveats on this one, so I wanted to show them sort of side by side. So yes, individuals have the right to restrict or ask for restriction on the use and disclosure of their sensitive information, but only if that bill was already paid, and most of the time when it's coming to you, it has not yet been. They have the right to access their records, but only where an accounting of records is required to be made, and an accounting is not required to be made for payment, treatment, or operations, which is basically what we do as self-funded plan administrators. So in most cases, we won't even be doing that accounting. Breach notification, that's always in play, and I mentioned that earlier. So as you see, there's a lot of caveats and sort of finessing in the rules. The HIPAA security, these are all of your computer stuff. So there's a separate set of rules there. And so if you have a security team or an IT team, it's very important that if you have to comply with HIPAA, that you are coordinating with them as well. You need to have policies and procedures that consider your network security. And I'm sure they have it, because it's pretty standard today to have these kind of protections in place, even on systems that aren't subject to HIPAA. But you want to make sure you're coordinating with them and you have that all documented. The highlighted items on the screen are those items that you personally, as the individual at your company, would be personally responsible to make sure that you are doing. You need to make sure that you have done your training, and if you have a policy or you're responsible for developing the policy, that you do so. If you need help with that, let us know. You need to make sure that if you have HIPAA folders, they're limited access. You work with your IT team to make sure that only you or a select few can access those folders. Make sure you're securely storing any emails, census data, claims files, anything that has PHI in it, in that restricted access folder. Make sure you're not talking about PHI in a public setting or with individuals who don't need to know that. If you are sending by email any sensitive information, make sure you're encrypting or using a password protected file. We see that a lot with census data, for example. If you're bringing guests into your office and you have sensitive information laying out, they have to be escorted. So some basic reminders. You want to make sure sort of at that first coordination phase with your security team that you work with them on conducting the risk analysis on your security system to make sure that you know where sensitive information is coming in and flowing out, where is it being stored, and make sure that your policies between IT and what you guys are doing are coordinating and consistent. So they probably have a lot of policy already about auditing and updating systems. And so there's a lot that sometimes we don't know about the other side of the house. So we just want to make sure we're coordinating and having that specifically written somewhere and documented well. So let's do your specifics. You need to make sure that you've done the training. There's usually two types of training. This training I call privacy training, and security training tends to be something that your IT or security people do. And it usually looks like cybersecurity training, like, you know, how not to get caught up in any phishing emails, for example. So make sure that that training is being done, that it's being recorded, and then it is consistent and sufficient for your level of involvement with sensitive information. You have to have a HIPAA privacy officer. You can also have a partner kind of arrangement where you have a liaison as well, a contact person, maybe somebody who's the contact person, but the privacy officer maybe is your legal counsel, who would be in charge with investigating any breaches, or if the Department of Health and Human Services audits, that would be the person that they would contact for any of the auditing. You want to make sure that a risk analysis analyzing the sensitive information you have, it's important to know what you have, who's accessing it, where is it, in order to know how you protect it in each phase that it is within your organization. And that's what HIPAA requires. If you're transmitting over the email, any sensitive information, make sure you're always encrypting or password protecting. The only safe harbor, which is your get out of jail free card, is if you encrypt, but password protecting is usually sufficient enough for entities that only have minimal involvement with protected health information. Make sure you're getting your appropriate contracts in place with your business associates, and there are some contractors as well. Make sure you're complying with any breach notification. That one is a sticky one. If there's any breach, and let's say people do this where they don't report, if the Department of Health and Human Services ever got wind of something like that, the penalty is so much higher for not handling the breach appropriately. So I think it's kind of commonly heard that, you know, if they don't know, what's the harm? But the harm is that you get a much bigger penalty. You can go to the OCR website, that's the Office for Civil Rights, which is an arm of the Department of Health and Human Services. And they have a portal there where you would actually do the reporting. You can also see everyone else's non-compliance. Which is, it's fun for me to do. I'm going to tell you a story since we have a few minutes extra. So my ex is a surgeon, and I actually saw, after we broke up, saw him on there, or his physician practice on there, and I got a hoot out of it because, you know, sometimes doctors are the last ones to listen to a compliance officer telling them something. So it's fun to sometimes just look at it, just for fun. So always be aware of the states that you're operating in. If you're in states other than Montana, for example, and you check out the news.leavitt site, we keep a track of the privacy laws that are happening throughout the country. Make sure you're staying on top of that. You can subscribe to our newsletter there at news.leavitt.com. And get those articles automatically when they come out. But you can also go to that website and do a search as well. Make sure use less information. Sometimes people try to give us a lot more information than we need. If the people are sending you emails and files that you really truly do not need to keep, delete them from the archive, get rid of them. The less you have, the less you have to worry about what would happen if there was an incident. The security incidents have just exploded since the pandemic. Literally, I've heard the terms like a 9/11 attack and the massive scale of hacking that has happened on businesses since the pandemic. So the less you have, the less you're going to have to worry about what happens if you were unfortunately somebody who got caught up in that. And there's a lot of them you can't do much about. These hackers are very sophisticated. You've heard of some of them. The pipeline one we heard of during the pandemic. We've heard of several of them, and they're pretty sophisticated. So sometimes there's nothing we can do. But if you've complied with everything HIPAA has asked you to do, then and you've handled the breach appropriately, then you wouldn't be penalized for doing for being a victim to a hacking when you did everything you should. And then HIPAA certification is usually the carrier wants to know your plan documents say that you're HIPAA compliant before they share sensitive information with you. I was late, but I'm still on time. This is great. Okay. So what is the disease you get from too much HIPAA? I can't see you, so I don't know if you're answering, so I'll just say hepatitis. We don't want that. We don't want any hepatitis. No. So that is our high-level introduction for self-funded plans to HIPAA. If you are interested, we also have additional content, and I'm not going to do it today because there will be a little bit more time than we have today, and also I don't see anybody else, so I'm not really sure. But we have a compliance HIPAA jam, as I like to call it. It's a Jeopardy game. So if you like Jeopardy, it's fun. I can always share with you the link. So just reach out to your Leavitt Group representative and ask for that. I will share with you the link. You can use it to test your knowledge or your team's knowledge at your organization when it comes to HIPAA. So it's just a fun way to do a knowledge test. You're not required to do anything other than that. But it's just one of the components is you should have a knowledge test. So I always like to do it in a fun way. But in the interest of time today, we won't do it today. We will have a follow-up email. These slides will be provided to you. There will also be a recording. And then again, let us know if you have any needs when it comes to HIPAA compliance. We have the full suite of resources at no cost to you. So please utilize them if you're a self-funded plan, because you're required to. And then if you want any individualized consulting with me and your team member at Great West, let us know. I am available to do that as well for you. So reach out, let us know how we can support you further when it comes to HIPAA or any of your other employee benefits compliance needs. And hopefully we will see each other again sometime, or at least you will see me and I will see a face to the name. And I hope you have a good rest of your day. Okay, bye-bye.